Let's welcome Mr. Bush.
Good morning. How is everybody? That's a little loud, but that's all right. I'm a little loud anyway. I could probably do without the mic. So, how many attorneys do we have in the room? Attorneys, real high. I see 1, 2, 3, 4. Any other attorneys? Okay, great. I'm going to ask for your help in this presentation because this is something that I've been thinking about for some time. I mean, you know, you guys have probably all seen me do the post-loss obligation seminar. You've either seen me speak on it or you've seen me talk on these in our classes, or the appraisal, or the ensuing loss, concurrent causation, which was mentioned earlier. So I've kind of worn all those out. So I wanted to bring something fresh and new to you today. And I want to talk to you about affirmative defenses and how to prevent them pre-litigation. All right? So I want to talk, that's why I want your help, attorneys, because I want you to talk about how these affirmative defenses have hurt your case and how if the public adjuster had just done something different, it would have helped us. It would have made things better on the back end, all right? So this is going to be very educational, and it should be very helpful to you in preparing your cases, not only pre-lit, but to help you get them settled too, a lot faster, all right? Now, hopefully at the end, and if Sean and Melanie will let me, we can talk a little bit about all the fraud. I know Doug spoke earlier in the week about it, but he has a little bit of a different perspective because he's seeing things after I've already gathered all the information and have sent it to him. And there's a lot going on the front of the fraud. So hopefully we'll have a little bit of time to where we can talk about that. So let's jump right into this. Affirmative defenses. How many of you know what an affirmative defense is in litigation? All right. So what happens is we file a complaint, right? The complaint alleges breach of contract. Everybody understands that. Well, the rules of civil procedure say that if you file a complaint against somebody, the court gives them an opportunity to answer that, right? So they answer the complaint, and then they have the opportunity to defend why they did the behavior that they did or why the behavior that you're claiming they did not do. The affirmative defenses is that part of the litigation. Now, has to be filed in every case, except I have a case right now going to trial June the 20th where the defendant filed no affirmative defenses. None. Is that making sense to you? Doesn't to me either, but I've got all kinds of motions in limine around that one, so we'll see what happens. So here's the first one that we're seeing a lot that's coming up now more and more and more and more. Now, remember, I practice in multiple states, and I saw this prompt notice come up in Florida first. Then I saw it in Georgia, and then I started to see it in Texas and see it in Illinois. So we're seeing prompt notice a lot popping up more and more. But this is an affirmative defense that was in one of my cases. All of these are affirmative defenses that I took from my personal cases to show you today. So plaintiffs failed to satisfy all conditions precedent to recover pursuant to the terms of the policy, specifically Universal. How many of us just love Universal? Nobody? John Pruitt does. They just paid for him a pool, a new house, a vacation. Wife got a big fat diamond ring. John Pruitt loves Universal. All right. Was notified on March 24th, 2021 of the alleged loss that occurred when? When did it occur? At the insured property. So pursuant to the subject policy, the plaintiff is required to provide prompt notice of a loss, which plaintiff failed to do in this case. 1 month later, and we get an affirmative defense saying that they didn't comply with the policy because they didn't provide prompt notice. What does prompt mean? What's prompt mean? As soon as possible, right? Prompt means as soon as possible. Well, in this case, this was a water loss. And in this water loss, my client had a plumbing company come out who could not find the leak. When they found the leak and they opened it up and discovered what it was, She immediately provided notice. But what was the date of loss? The date that it actually happened, right? All right, so, but we got an affirmative defense. Now, I have one public adjuster who has 18 condominium associations signed up from Hurricane Ian, and he has not yet filed any claims on those. What's going to happen in every one of those? What's going to happen? They're all going to be denied. So what's going to happen is I'm going to get a motion to dismiss for failure to comply with policy conditions. And then I'm going to have to go fight that. Now, the law in Florida has changed so much so on prompt notice that I have about a 50-50 chance of winning. What's going to happen to those condominium associations? All right, so if you have a loss, give prompt notice. Don't wait, all right? Give prompt notice. Defendant asserts that plaintiff failed to satisfy all conditions precedent to recovery pursuant to the terms of the policy. Specifically, plaintiff failed to provide a proper notice of intent to litigate. Now, how many of you understand what the notice of intent to litigate is? Who's working Ian claims? All right, so if you're working Ian claims in Florida, you now have to provide an NOI, a notice of intent. The problem with the NOIs is that public adjusters are filing them. Go ahead. A ton. All right, notice of intent is notice of intent to litigate. Civil remedy notice is we're claiming that you acted in bad faith. But in Florida, the civil remedy notice has no teeth anymore at all. Yeah, we're not even filing civil remedy notices because they've basically taken bad faith out in Florida. It's terrible. All right, so it's my opinion that public adjusters should not file the notice of intent. I know a lot of public adjusters online are claiming, I'll file it. You have to comply with all the statutory requirements, which means you have to interpret those, right? That's practicing law, in my opinion. This is what happens when a public adjuster files a notice of intent and demands that we file the lawsuit immediately and not refile a proper notice of intent. We get an affirmative defense. Plaintiff failed to provide a proper notice of intent to litigation as specified in the Department of Financial Services pursuant to the statute. That's the statute. Anybody else run into that, attorneys in Florida? You seeing it too? Yeah. Listen, the only reason why a public adjuster would want to file a notice of intent was try to put pressure on the insurance company. And that's the wrong motivation. All right? Same way they file civil remedy notices. They think that puts pressure on them. You know what they do when you do that? They laugh at you. You don't get anywhere. You don't get anywhere by doing that. But if you are insistent upon filing a notice of intent and you think you can get them to move by filing a notice of intent, consult with an attorney. Consult with an attorney, all right, so that you can file a proper notice of intent. Now, this is big, and I want to spend some time on this one because Universal, Heritage, Olympus, and Citizens are all filing misrepresentations as affirmative defenses in their policies. So what happens if they file an affirmative defense of misrepresentation and they win? What happens? The whole thing's gone. And they can do that on a dispositive motion, like a motion for summary judgment. Whole thing's gone. So, Universal asserts that damages are being sought in this action for items, listen, items and or areas of the home that were not caused by the alleged loss. Now, as a public adjuster, you should know that. Before that gets to me, or to Sean, or to any other attorney, you should already know that this is why they're not paying the claim. And you should already have resolved that, right? What items are you claiming are not caused by the alleged loss? What items? What are they? And then how can we resolve that issue? So failure Further in this action involves claims for damages. That includes numerous repairs that are excessive. That's typical, right? They say that about everything. Inaccurate. They say that about everything. Unwarranted. Upgrades are related to areas of the house that were not damaged. So how many of you provide explanations when you're seeking damages that was not part of the loss? Nobody? How about matching? How about ordinance and law? Do you send those in? Do you send explanations on those? Nobody? What are you guys doing? Are you out there? Hello? Am I here? Mark, am I here? Can you hear me? All right. I want to make sure. All right. Now listen, this is the part that I have to defend. As such, plaintiff has misrepresented her damages. What is that, guys? What are they setting us up to? Well, yes. No, all right. Preach. But what are they setting us up for? Fraud. So how are they going to do that? How are they going to get that? Depositions, right? They'll get that through depositions. So, plaintiff has misrepresented her damages, cause of loss, and the extent of the damages. Plaintiff, she what? What'd she do? Intentional. What's an element of fraud? All right. You see the pattern? You see what we're looking at? An inaccurate and inflated estimate of damages. I've said it. I know Cal has said it. I've heard Sean say it. John Pruitt has said it on stage. I've heard all kinds of people tell you, don't inflate your estimates. And your estimates must be accurate. They got to be accurate. You got to check and double check. That's your job, your responsibility. We depend on your estimates. We should be able to, so that your client and our client doesn't get an affirmative defense for misrepresentation. So, be sure that they're accurate. Plaintiff and her agent and who? You caught that, didn't you? And her agents. Who's her agent? You guys. You guys are her agents. So now who are they setting up? All right. Knew this estimate contained numerous entries and rooms that are in no way related to the cause of loss at issue. As such, there's no coverage under plaintiff's policy. See, this is a public adjuster who wrote and said, oh, I can get this room, and I can get this room, and I can get that room, and I can get this room. And now I've got an estimate, and I took it from $30,000 to $800,000. All right? But in this case, that's not the case. In this case, it wasn't. And this case got resolved because what I was able to do was to show through Mr. John Pruitt that this was not the case at all. And they wound up paying and settling out this claim. But my point is this is what we get, and this is what we have to defend. But we wouldn't have to do that if we could prevent some of it on the front end. It would make it a lot easier, and cases would settle in litigation a lot faster if they were cleaner. Are you guys attorneys? What's your name? Yeah, what's your name? Yeah, Matt, where are you from? Okay, great. Matt, you seeing any of this? Do you agree? No, do you agree that some of this could be straightened out on the front end and a lot cleaner, and that if we didn't have to defend these affirmative defenses, litigation would move a lot faster, and we could probably get these things resolved a lot quicker? All right? So, listen, I'm not trying to put blame on public adjusters. I was a public adjuster for 12 years. 12 years I was a public adjuster, so I sat right where you sat, did the same things you do. So I know. But what I'm trying to do is I'm trying to tell you what we're going through so that we can work together as a team. Because I don't care what anybody says, we are a team. I know they want to split us apart. They want to pit attorneys against public adjusters. But who do we all represent? The insured. We got to work together. right? But you need to know what's happening on our end, because too often attorneys don't talk to you and tell you, do they? Come on. Do attorneys call you up and say, hey, I got this affirmative defense today? Not at all, right? All right. So just a little. Exactly. So I want to shed a little light on this today so that you guys know what we're going through, and you can maybe help us to help you so we can help who? That's it. Because that's where our focus always has to be, right? Has to be on helping the policyholder. Pre-existing damage. As its first affirmative defense, Citizens asserts plaintiff's property did not sustain direct physical loss during the applicable policy period of June 17, 2021 through June 17th of 2022. Seen that one before? So how could we prevent that affirmative defense? As a public adjuster, how could you prevent that affirmative defense from coming to an attorney? Proof of loss won't help you. Weather reports, that's great. What else? Absolutely weather reports. What else? Date-stamped photographs before and after. How about that? How about inspections, or if somebody was on the roof, or or water loss, anything like that, anything that can show that on this date that happened. Dated invoices, anything you can find that helps. Those are all beneficial to help prove that a loss occurred on a particular date or within a particular policy period. That's right. That's right. Another one. Here's another existing damage. So as its fourth affirmative defense, defendant states that plaintiff's claims are barred to the extent that their claim damages were not caused by a covered peril, but rather were caused by existing damage. Damages resulting from existing damage are specifically excluded under the policy. That's true, but what happens if the roof is damaged and a windstorm comes through and it has 2-inch hail and the hail damages the roof? Is that roof covered? Nobody knows? Absolutely it's covered, right? So we don't care about the existing damage, right? We didn't make a claim for existing damage. What damages did we make a claim for? 2-inch hail, right? All right. But if you put that in a letter and tell them that, or if you explain it to them somehow that we have record of that, if we get this affirmative defense, now we have an argument, right? We have something that we can go against and say, no, you knew about this all a long time ago, but you stuck to your guns and you denied the claim based upon this in I heard it, somebody said it, in bad faith. In bad faith, right? All right, so post-loss obligations, my favorite topic. I love to talk about post-loss obligations because they are so important to the policyholder getting paid. They're the most important piece. And if you're not reading your policies and highlighting your post-loss obligations, you're really doing a disservice to your client. How many of you do that? How many of you read your policies and actually highlight or know what the post-loss obligations are in every policy? Only a few. All right. Those of you who don't, you ought to start doing it because every policy is different. They're different in State Farms. State Farm has 3 different policies in 3 different states. They're not the same. You need to know what those post-loss obligations are. Because if you don't abide by those, and we get it to litigation, Sean gets an affirmative defense that says plaintiff's lawsuit is barred because the plaintiff failed to comply with policy conditions to provide what? Wow, this is the one that makes me the maddest. This one frustrates me the most with public adjusters. Failed to provide all the documents and records that were reasonably requested. And they didn't request them once, they requested them twice. While a showing of prejudice is not required anymore. It's not required. The defendant was prejudiced by the plaintiff's failure to comply with the terms of the policy because it was prevented from being able to investigate all material facts of the claim pertaining to the cause and extent of the loss. That's a serious affirmative defense right there. So, in litigation, if we get this, and we find out that those documents that were requested on April the 27th and July the 8th were not provided, what do we have to do? What must we have to do now as attorneys? Attorneys? Matt, what you going to do? Or dismiss the case and start over, right? Because they were prevented from being able to investigate all material facts of the claim. No showing of prejudice anymore in Florida. Do you guys still have to show prejudice in Texas? You do? All right, so maybe you wouldn't dismiss. I would have to dismiss in Florida. All right. Now, we have the notice of intent statute now in Florida, right? So what happens if I dismiss this case based upon the new notice of intent statute to comply and refile? What does that now subject the policyholder to? One more time. Paying the other side's attorney's fees. Didn't think about that, did you? Now our client's subject to having to pay the other side's attorney's fees. See how serious it is? Serious. Now y'all wonder why we drink so much? Because we have to deal with this. And listen, if you're a defense attorney and you had this on your plate, what would you do? Right? You'd hammer it home. That's what they're doing. These are things that they're doing. Now, in this case, in this particular case, what I discovered was the public adjuster, because I only work with good public adjusters. I've weeded out all the other public adjusters out of my life. I only work with the good ones. This public adjuster did comply. He provided them the documents that he had on on July the 8th. He did not do it on April the 27th, but on July the 8th, he did respond with documents that he had. And what he said was, here are the documents we have. He didn't take it one more step and say, we do not have items 8 through 16 or items 2 and 10 or 5. So we were able to get around this affirmative defense, but it took us months before we were able to get around that affirmative defense. All right, the plaintiff's claim is barred and or limited to the extent any damages are the consequence of constant or repeated seepage. Did you hear that a lot, guys? Oh, my Lord, isn't that crazy? Don't you hate that one? Or leakage of water or steam, which is excluded under the policy. Now, Trey has a water loss presentation that he's done many times, and he's done it here on this stage. If you haven't seen it, you ought to see it. And he can show you how to get around this provision of the policy. But listen, what could you do as a public adjuster to help us to show that this was not the consequence of constant or repeated seepage up front? What could you do? All right, I actually have a case with this. This is what this was pulled from, actually, that case against Heritage. And my client, she showers in this shower every day. And because of the location and the fact it has no light in there, and it's kind of a closed-in area, it gets really wet. And she's a little bit of a neat freak, so she takes a towel and she dries the floor every day. What is that? That's a habit, right? She's created a habit of drying that floor every day. So we were able to get an affidavit from her to say, this is what I do, this is what I do every day. I never saw the leak until this date. And on this date, when we saw the leak, we notified the carrier, X, Y, and Z. All right, so those are some things that you could also do that would help you. So if you could get over that objection, you might could get the claim paid and it never even come to an attorney. All right, those are some things that you could do. What else could you do besides the pictures, interviewing the client, getting an affidavit? What's something else you could do? Right, and getting the expert to say, was this constant or repeated? This does not appear to be constant or repeated. This appears to be what? Oh, you guys are good. You're good. All right, here's another big one. And public adjusters, you guys are really bad about this. You don't get tarps. Why do public adjusters not get tarps put on roofs? You know it's leaking. You know it's leaking. To the extent that the damages alleged by plaintiff is the direct result, in whole or in part, of her failure to mitigate, minimize, and or avoid the claimed damages, including failure to periodically inspect and properly maintain the subject property, the plaintiff is barred from recovery under the terms and conditions of the policy. Now, listen to this, including failure to what? Periodically inspect and properly maintain the subject property. How are you getting over that one? Think, guys, this one's easy. Exactly. Repair, any repairs that they've done to the home. Home Depot receipts, anything that shows, you could show the rest of the condition of the house, right, to show that they did not fail to properly inspect and properly maintain the subject property. I actually have, this is, like I said, this is another one of my cases. And in this case, my clients are 80 and 87, and they have failed to periodically inspect and properly maintain the property. So what am I going to do here? What am I going to do here? Well, I'll tell you what I'm going to do. I'm going to make lemons into lemonade. And I'm going to put as much sweetener in it as I can, right? And I'm going to get them paid. I'm not going to get them paid what they should be paid, but I'm going to get them paid something in hopes that they can take that money and do some work. But this is big time. So if you have this and you come across this out in the field, what should you do with this case, with this claim? As a public adjuster, what should you do? I think I'd find the next claim. Right? If they have failed to properly maintain, then it's time to move on. All right? So, or you look at it and you say, well, what are the damages? And did those damages actually do damage to the properly, failed to properly maintain the subject property? Did the damages cause more damage? And how can you prove that, right? So now what situation do we have? You had it. Concurrent causation. Now we have concurrent causation. Exactly, right? So there may be another way to skin the cat. We just have to look at it. All right, no covered peril. Ooh, this is a good one. I just was talking to TJ back in the back. I have this case, or had this case on a big $4.5 million church in North Carolina. The public adjuster waited too long to bring it to an attorney. It went past the suit limitations period, so they picked up another date of loss. And when they picked up that date of loss, I spent $1,200 on a weather forensics report. I mean, I got a good one, right? The closest wind damage that even could do any damage to that property whatsoever within the policy period was 8 miles away. What am I going to do with that? Exactly, that's what I had to do, right? But I tried, right? I tried to do something, but I couldn't do anything with it. So it's a second affirmative defense. Defendant states that plaintiff's claims are barred to the extent any of their claim damages were not caused by covered peril, namely windstorm or hail. This is why you got to make sure you have the right peril when you call in a claim. I see these claims called in all the time with wrong perils. Be sure you got the right peril, but instead were caused by inadequate maintenance, poor workmanship, and or improper repairs. And my favorite one of all, wear and tear. They fall into wear and tear. So let's talk about the wear and tear. Now, number one, we didn't make a claim for wear and tear, did we? What did we make a claim for? Wind. That's exactly right. So we don't care about wear and tear. You can have all the wear and tear it wants on it. Every house in America, every building in America has wear and tear, right? Everybody agree with that? All right, so what does wear and tear have to do with anything? Only, right? But do we have damage? If we have damage, that's all that matters. So let's take a look at this. And this is a case and that is out of Florida. It says the damages are caused by the windstorm, hurricane, and therefore relate to the wind, not by wear and tear, deterioration, or inadequate maintenance, as the defendant has pled. The plain language of the exclusion. Now listen, this is policy interpretation. You guys need to get this because this is going to help you. If you have your cameras, take pictures of this slide. This will help you in your arguments. The plain language of the exclusion refers to losses resulting or caused by wear and tear, deterioration, etc., which is clearly intended to apply where wear and tear, marring, and deterioration or the like is the cause of the property damage. Got it? Where it was the cause of the property damage and is not designed to preclude coverage when damages from a windstorm or hurricane is the cause of the damage itself. Significantly, all of the terminology utilized in the subject exception to describe what constitutes wear and tear consists of expected, natural, say it for me, degenerative processes demonstrating that the clear purpose of this exclusion was to prevent against ensuring ordinary inevitable losses. And that's the case. Now, you could take that, you could simplify that, and you could use that in your argument for wear and tear, right? And you don't have to quote case law. You can just say, look, it's my understanding that and the way we interpret the provision to be is X, Y, Z. Now, you might can get over some wear and tear issues. Here, windstorm hurricane is the cause of the loss to the plaintiff's home. And I've won some summary judgments on these, on wear and tear. Neglect. As its third affirmative defense, defendant states that plaintiff's claims are barred to the extent that their claim damages were not caused by covered peril, but rather were caused by neglect. Damages resulting from neglect are specifically excluded. I don't even know what to say about this. This one just aggravates me. How do they know it was neglect? Number one. So how would you get over that neglect? Who? Right, so you would get maintenance records, Home Depot receipts, anything that shows they did not neglect the property, right? All of those things will help you. So, big one, citizens. Those of you working in Florida, again, and what policy in Texas has no storm created opening? There's two policies, I think. Who? Allstate, and who else? Is it Toya? Okay, I knew there was two. I'm licensed in Texas as well. I don't do a lot of cases in Texas, but I oversee attorneys in Texas. And overseeing those attorneys in Texas, I get a lot of law and stuff. So anyway, as the third affirmative defense, citizens asserts any right to recovery by plaintiffs is limited pursuant to the following provision of the subject policy. The subject policy does not provide coverage to the interior of the property caused by rain unless a covered peril such as wind or hail creates an opening in the roof or wall. All right, so citizens goes on to say that their pre-suit investigation, namely inspection by a licensed field adjuster, Donald, and how do you say his last name? LaChance, on July the 29th, 2022, and Rudy Castillo, PE, on September the 14th, 2022, who observed no openings caused by wind or hail on the roof and or exterior of the home. So in deposition, what am I going to focus on? Yeah, because they just told me that they didn't even try to find one. All right, so I'm going to try to find out how they found one. But I'm going to send John Pruitt out there, and I'm going to get John Pruitt to give me all kinds of photographs. He's going to document stuff for me. He's going to send me his report, and then I'm going to put it in front of them in deposition, and I'm going to try to destroy this affirmative defense. Right? But I wouldn't have to if I knew where it was ahead of time. So when you're inspecting the roofs as a public adjuster, and you know the policy has a storm-created opening requirement, what should you be looking for? All right, are you doing that? Good. I see some heads nodding. Good. That's very important. It's really important. It really is. Because these kinds of things that you see right here are what we have to fight with, which could cause a case to get dismissed or us to lose a case, right, if we can't prove it. And if you get with a sorry attorney who's not going to go after this, let's face it, there are some out there, right? They're on both sides. Well, it depends on the roof, right? But in most cases, you're going to start in the attic. And you're going to start there and work your way backwards. John, what would you say? Okay, this is the big one now that we're seeing, and we're seeing this because of all the traction that we're getting with the carrier fraud. So now what they're trying to do is make everything about the insured fraud, right? Which they've been doing for years, but now it seems to have picked up. Defendant alleges that the plaintiff's claim for damages is unreasonable in scope and or amount cost, as plaintiff's repair estimate contains unnecessary and inflated charges. Now, we saw that earlier, right? And another affirmative defense, and that one was misrepresentation. This was a affirmative defense for fraud. Same thing, right? Says the same thing. Defendant alleges that there is no coverage for the alleged loss, as the defendant's investigation of the claim revealed there is no direct physical loss. No direct physical loss to any covered property on the alleged date of loss. Remember the one I just told you I had in North Carolina? If I'd have filed a lawsuit on that, bam. That's what I would have gotten. So, we've got just a few minutes, so if I can take just a few minutes, we'll talk about the fraud a little bit if you guys want to. But I know that's not a very exciting and not a very sexy topic, right? Because it's putting you on the hot seat, and I do want to put you on the hot seat because I don't want you to be good. Anybody can be good. Anybody can be good. I want you to be great, right? Be a great public adjuster. I tell my attorneys that I work with every day. I tell my staff every day, listen, be great today. Don't be good. Be great. Be great. And if we'll do that, we have to because we're under a microscope. So let's talk about the fraud that we've uncovered. One of the whistleblowers is here, Mr. Mark Vinson. Mark, stand up. So when Mark and them first came to me and I started looking at all of this, at first I was like, what? And I knew it because I had been getting it in depositions, but I didn't think much of it in depositions. So when it started coming out and they brought it to me and then they showed me how we could prove it by getting the exact analysis, right? When we got the exact analysis and we started proving the fraud, now we had all of the dots that we could connect all the way up. And that was very beneficial to the state. So I've had the fraud investigators in my office. We talked to them over the phone. We've been emailing back and forth. They are actively investigating in Florida now. And I haven't said a whole lot publicly because and we've been very careful. We got a little bit of criticism on the NBC Nightly News for not going far enough. Well, we can't. We can't. all right? You have to understand that we have to be strategic in what we are doing, because if we're not strategic, what will the insurance companies and the TPAs do? Destroy evidence, right? That's what they're going to do. So we have to be very careful. We have to be very strategic in what we're doing. But here's what I can tell you. The investigations for fraud in Florida are progressing on along. I now have proof and evidence of carrier fraud for the same purposes in Georgia, Texas, Louisiana, California, and somewhere else. I can't think right now. I lost my train of thought. But I have, and we are going to be bringing some lawsuits in those states specifically on these issues first, not in all of them, in some of the states, right? So we had to go to the DFS first to get the investigation in Florida. It was just a strategic move. Now we'll come back behind and we'll start filing the lawsuits after the investigation's over. In Georgia, we're going to handle it a little differently. We're going to have to file the lawsuit first, and then we'll get the evidence that we need and take it to the Department of Insurance, because it's my understanding that they really aren't concerned about it, and they're not going to do anything about it. They don't care. So we're going to have to get it, and then we're going to have to put pressure on them, like we did Florida, to open up and do an investigation. All right? So go ahead. Yeah. It's going to be something else. All right. Any questions or comments or anything? I think my time's up. Anybody? All right. Well, I hope this was helpful for you guys. And thank you again for letting me come and talk to you.
Can we have one additional round of applause for Stephen Bush? I know a lot of us have benefited from the materials he posted and the research that he's done.